Shall we start, ma'am?
Yes, so now we are live on YouTube as well.
Okay.
So we can start with the session. Let me give a small introduction of yours and Ajay sir, and then you can start the session. Hi friends. I hope you all are doing well. I welcome you all in this webinar, and the discussion is on important legal principle, law of precedent. So we have here with us CA Prakash Sinha sir and Advocate Ajay Kumar sir. So let me start with the introduction of Prakash sir. So Prakash sir is a very renowned chartered accountant and very experienced chartered accountant. He has taken many webinars. In fact, recently only he took webinar on a budget with our team as well. So he is such a vast source of knowledge, and he has he doesn't need any much introduction. उनको introduce करना मतलब सूरज को दिया दिखाने के बराबर है, कि सर को इतनी knowledge है इतनी सारी चीजों के बारे में. इनफैक्ट अगर हमें भी कुछ कभी गाइडेंस चाहिए होती है तो हम सर से ही डिस्कस करते हैं. And let me also welcome Advocate Ajay Kumar sir. So Ajay Kumar sir is a very well-known advocate, and he's on record of Supreme Court. He's very talented and experienced advocate, and he's very valuable team member. He has experience of more than 20 years on various matters of litigation, which cover tax as well as non-taxation matters like FEMA, corporate law, insolvency, and other matters, which include with various High Court and Supreme Court. He has expertise in contractual matters and handles various arbitration issues also. So I welcome both Prakash sir and Ajay sir with us, and without wasting much time, because I want audience to have maximum time of yours, I request you both to start with the session. Thank you, sir.
Thank you, ma'am. Thank you, Studycafe, and thank you all the participants for giving us the opportunity to discuss the important legal principles here. This discussion is not per se on the tax law, but this discussion is on the important legal principles that a chartered accountant or an advocate that has to adopt while he is arguing a case. And this issue is that how a precedent has to be selected, what is the ratio decidendi in the case, what is the obiter dicta in a case, what is how to select a cases when we are arguing a matter before a tribunal or CIT appeal or high court, like anything here. Because we generally see that whenever some matters comes to us, we try to find out which are the cases through which it is covered. Simpliciter saying that it is a covered matter, whether it is really a covered matter or not, how to understand the term, whether it is a covered or not, whether all the issue which has been, how to extract a judgment, how to read a judgment, and how to understand a judgment, and for particularly how to cite a judgment here, because we should be aware that we should not be citing anything which is not relevant in a particular case here. Otherwise, our appeal will be totally overloaded. I will tell you that is overloaded, and we will be lost in the documents here. So our selection of the case law should be very precise here, saying that yes, on to this point, this is judgment of the some higher or superior cases here. And in order to understand the law of precedent, what is the ratio decidendi, what is the obiter dicta, and what is the binding precedent, and when a case is said to be a binding, we will run through different judgment of the Supreme Court, mainly of the Supreme Court. We will not take up any judgment which is lower than the Supreme Court, or if suppose that we will take up this matter, yes, and it will be open session. You can raise your hand, you can very well discuss this issue, And for this purpose, we have Ajay ji. Ajay ji is very experienced advocate on record of the Supreme Court, and we will start the discussion on that matters here. For this purpose, we have segregated our discussion on mainly on the 7 part here. First is that we will start our discussion with the Article 141 of the Constitution here, because what is the power of the Supreme Court under Article 141 and why it is required, what is the consistency of the law and the judicial discipline, which are the essential for the administration of the justice. After this discussion on the 141 issue of the Supreme Court, we will come down to discuss the broad principle of precedent. What are the broad principles of the precedent? In these cases, we will discuss some few cases that is one of the cases is Preet Srivastava. We will also discuss the MP Aparao case here, and after that the Ambika Query case of the Gujarat, Ambika Query case, Ambika Query versus Gujarat, state of Gujarat. After that, we will go to discuss about the general exception of the rule, whether this rule of the principle of the precedent applies everywhere, or is there any exception can be taken, and how to read the exception here. Then we will discuss that what is the difference, what is the issue of the per incurium, when the judgment is said to be per incurium and when a judgment is called to be a sub silentio. These are the important principles that is a part of the exception rule of the law of precedent. After that, we will discuss some how to read the precedent, whether the court has to necessarily follow the precedent. And for this purpose, we will discuss some few of the important part of the famous case of the Golaknath, which was prior to the Kesavananda Bharti case here. We all know that part here. In the tax matter, we will be discussing some part of the Vodafone case. However, and one more important case, which is a Journal Singh case, which is a recent case of the January 2020, where the issue of the reservation was discussed. Here we will discuss the Indraswani case here and other cases here, where about the how to read the precedent here. And in this case, in the Journal Singh case, lot of discussion is on the prospective overruling also. Then after this part, we will switch over to the part of the judicial discipline. What are the judicial discipline? This means the binding precedent of the Supreme Court cases. We know that we have Article 141 and Article 142. How to read these two articles here and how the binding principle is there. And for this purpose, judicial discipline, we will discuss the Mutulal case, that is coming from the 1974 Supreme Court cases here, 2 SCC 374, Lakshmi Shankar case, Dalbir Singh case, and Pradeep Chandra Praja case here, Parija case here. After that, we will come to the recent cases here. What are the recent cases? Recent cases, one of the cases we know that it was a constitutional bench judgment of the Dilip Kumar Gupta cases here. Dilip Kumar in the customs matter. It was a 5-judge bench. We will discuss the constitutional bench judgment. Then after the government of Kerala versus Mother Superior Convent, how to read this. This is also important for the purpose of income tax, because in this case, the issue of the charitable organization was there, and whether the hostel for the purpose of the nurses, how to treat this part here. After that, there is a Dilip case, SK Raju case here, and Punjab versus Baljinder Singh case. These are the recent cases, and Pradeep Vinod construction. This is the coming from the arbitration matters, and Manraj Enterprises 221 Manraj Enterprises. These are the important cases. So let's start with the Ajay sir here. And I will request him to start his presentation on that, whatever on that on this topic. And after that, we will start with the question answer and going through each of the case law. Over to you, Ajay ji.
Thank you. Thank you so much, Prakashji.
Mhm.
Thank you. And uh, like you explained, I think you have given a complete ambit of the area in which we have to travel. And you rightly said that the precedent is something, Prakashji, that every lawyer, every chartered accountant, every person who has to do something with the court proceedings or judicial proceeding or a quasi-judicial proceeding has to deal with the precedents, has to deal with the decisions which are covering the field. Now, if you see, everyone will realize, everyone who is into this area of legal practice, they would realize that it is not only the law made by the legislature which is governing the field. I think 90% of the law is the judge-made law, which is called the common law, which and therefore it becomes singularly important for all of us to understand the law of precedent and to understand how a judgment is to be applied, how a judgment is to be distinguished, how a judgment is to be held not applicable, applicable, pre incuriam, silentio, etc., etc. Now, therefore, to start with the basic, I need not say, but I'll point out that what 141 article says is that every judgment of the Supreme Court shall be binding on every other court in this country, which means that it's not only the law or declared law made by the legislation, but the law declared by the Supreme Court also becomes the law of the land and is to be followed by all and sundry. And consequences of non-following is provided. If the executive doesn't follow it, there are consequences under 215 and 129 of Constitution, where under the contempt is the remedy. But then judiciary is required to follow it for the purpose of maintaining judicial discipline and for the purpose of maintaining consistency in the administration of justice, which is in a huge country like ours, where there are a number of courts and tribunals which are functioning simultaneously. It is very important to have a consistency of law, and therefore it's very important to understand how these precedents do work. Now, for the purpose of convenience of everyone who has joined, I would like to share on the screen some PowerPoint thing which will give us the lighting factor as to how should we go about it. So I'm just sharing that screen, and thereafter we'll take it up from there. Now, I hope the screen is visible to all of you.
Yes, sir. Your screen is visible.
All right. So, yes. So it says precedent means stare decisis. That means stand by the things decided. That's the Latin term, and which we have already said. The Article 141 says law declared by Supreme Court to be binding on all courts. The law declared by Supreme Court shall be binding on all courts within the territory of India. Now, why it is required, I briefly mentioned now, is that law made by legislation and law made by the court. The limitations of legislature is that it cannot make law on every point, and it cannot foresee every eventuality that or every fact that can come across when a law is to be applied, and therefore the law made by the legislature is required to be given an interpretation, and that interpretation becomes the law made by the court, right? And therefore law made by the court, and to follow that law with the rule of consistency becomes very important. Second thing is, like I said, it's very much required for the purpose of consistency in administration of justice. Otherwise, different courts will take different view, and they'll become completely chaotic. And third is to maintain the judicial discipline, that the law of precedent is, or the rule of precedent is required to be followed very diligently. Now, thereafter, if we go next, what binds and what does not bind in a judgment or a precedent which is declared.
Ajay ji, may I request
Yes.
you to just enlarge, because it is not visible right now. Enlarge your screen here.
Is it better?
Or can you go to the presentation mode? In this case, there is a presentation mode. right hand side there will be some presentation mode, or otherwise you can continue. Yeah.
All right. So what binds in a judgment and what doesn't bind is, it's very clear. There's something called ratio decidendi, that is the reason for deciding a case that binds. If we see what is the principle of law culled out from the application of legal provisions to the attending facts and circumstances of a case. Now, whenever we apply a judgment, we apply a ratio of that judgment. And for the purpose of application of ratio, it is very important that the facts of that case and the facts in which you are seeking to apply those decisions should be similar. And what doesn't bind is the obiter dictum, which is said in passing, like observation made in passing. Constitution Bench of Supreme Court in H. Maharaja Sindhya, Madhavrao Sindhya, has observed on obiter dictum like this, referring to the water law lexical, which defines the term obiter dictum as an opinion not necessary to a judgment, an observation as to the law made by a judge in the course of a case, but not necessary to its decision, and therefore of no binding effect. Often called as obiter dictum, a remark by way, a decision on the point is not necessary for the purpose of, or which does not fall from the determination in decision, becomes an obiter dictum, which means that essentially what the facts and law which have been applied in a particular case, apart from while discussing that judgment or while discussing that case when the judgment is being pronounced, there are sub observations that may come from the court which doesn't have to do exactly about the fact and law, and such observations are not necessarily required for the purpose of adjudication of the dispute in the matter. The list is not dependent on such observation. In that case, such an observation will become an observation which is called obiter dictum, and it is not binding to the extent to which the judge is saying something which is not intrinsically connected to the facts and law applicable in that case, and which is not at all required or even somewhat required for the purpose of determination of the real question in that case. That observation cannot be used as a binding precedent. That is what is called obiter dictum. Thereafter, any decision which the Supreme Court renders in exercise of its inherent power, considering the special facts and circumstances of a case, those judgments are not binding. They do not present the precedential value. Apart from that, where a judgment is rendered on the basis of a concession made by the parties, even those judgments cannot be binding. And references of those decisions of the Supreme Court can be found in the screen. Dalbir Singh versus Punjab, it was said that any judgment which is rendered by Supreme Court exercising its inherent power. As you might be knowing that in a Supreme Court under Article 142 has inherent power to do substantial justice. It can pass such orders which it might not pass in other cases. But since the facts and circumstances of that particular cases are so compelling, that if no such inherent power is exercised, probably the substantial justice would be not rendered. So in order to do substantial justice, this is done. And an order may be passed under Article 142, which is the inherent power of the Supreme Court. But whichever orders or judgments are passed by Supreme Court in exercise of that particular inherent power, no one should use that judgment or order as a precedent, saying that this has happened in this particular case, therefore this should happen in my case also. This doesn't become a precedent. Similarly, where a party concedes, assuming that on the facts of law in a given circumstance, one of the party, considering its particular or peculiar situation, concedes that all right, I am agreeable to this thing, and based on that concession, a judgment follows. That judgment is confined to the facts of that case, and that shouldn't be taken as a precedent. So any judgment which is coming on the basis of the concession should not be taken as a judgment for the purpose of a precedent. Now, in Preeti Srivastava versus MP, and in Appa Rao versus SEC, the question becomes as to, these judgments, who are bound by it and who are not bound by it. Like 141 says article, that all courts in this country within the territory of India are bound by it, which naturally means that Supreme Court too is bound by its own decision. It cannot take a different view unless if it decides to take a different view, or it decides to take a different course, then there are method prescribes how it is to be done that we'll discuss in a while from now. So Priti Srivastava and Apparao, and there are umpteen number of cases. I think in every third case you get an instance of binding value and some observation by the courts on why this judgment should be binding, why not, because there is not a single case which is not decided by the strength of precedent. So these two judgments and other such judgments, they have said that any judgment which is rendered by the Supreme Court by virtue of Article 141, it becomes the law of the land, and therefore it binds everyone. It binds the lower court, it binds the lower judiciary, it binds high court, it binds every other authority. Now, what is binding on the subsequent judge deciding any case is the ratio decidendi of the previous decision. That is the principle culled out from the discussion of attending facts and law applicable to that case, and not obiter dictum that we have already discussed. Any stray observation is an obiter dictum, which is not required for the purpose of adjudication of the case, and therefore that's not binding. Ambika Quarry was the case in which they said that a case is a precedent or authority only for what it actually decides and not for what logically follows from it. Now, in a very recent decision that we'll discuss in detail after some time, Mother Superior Convent, when Justice Nariman was deciding the question of applicability of the property tax on building, which was being used for the purpose of a hostel in which nuns or students of a religious institution were to be housed for in order to see that the functioning of the religious institution is properly undertaken, because the question was whether that building can be exempted from the ambit of property tax or not. And state came forward taking shelter of Dilip Constitution Bench decision in Dilip Singh or Dilip Kumar, that and said that exemption thing is to be construed strictly. And therefore, this since the language of the statute doesn't say hostel, it should not be given, the benefit should not be extended to the hostel. There, Supreme Court had the occasion to actually distinguish the Constitution Bench of Dilip Singh, saying Dilip Singh decides a particular question, and it doesn't touch the particular aspect which is involved in this case, in convent case, and therefore Dilip can be a case for what it has decided, and it cannot be taken as a case to cover this, saying that this logically follows from that. So we'll see that subsequently as to how that judgment has to be dealt with by Supreme Court. Now, are all ratios binding? Now we'll deal with the exceptions to this rule, where the precedent is normally to be followed. There are exceptions, and based on these exceptions, either the judgments are not followed, or they are distinguished, or they are somehow made not applicable to the case which is being considered. Now, tools to distinguish a ratio as not binding. First is per incuriam, which is lack of care. A judgment rendered oblivion of a statute, material applicable law, or binding authority is a judgment rendered per incuriam, and it shall not bind the coordinate or the subordinate court. It clearly says that while deciding a particular case, if the lawyers arguing the matter and the judge hearing the matter, in the entire discussion of the matter, if any particular statute which is relevant for the purpose of deciding that case, or if any particular law which is applicable directly for proper adjudication of the case, or any particular authority or precedent which is directly covering the field, if they have not been brought into consideration and the judgment is rendered, and if tomorrow somebody relies on that particular judgment in his case, then the other side can take a defense of or take an objection of per incuriam, saying that that judgment cannot be made applicable because of the reason that these things have not been there. The relevant law which is applicable has not been discussed there or not been taken into account. Similarly, second tool of precedent not being binding is to take a plea that the precedent is not binding. It's sub silentio, which is in silence. That means that though the law which is applicable is being discussed, but a particular point of law is not perceived or understood or actually catches attention of either arguing counsels or the judge. And that particular point of law was so relevant that had it been considered, then the outcome of the case would have been something else. So the difference between per incuriam and sub silentio is that where per incuriam, this is like completely out, that law is completely out, not being discussed at all. Here, the law is being discussed, but a particular point of law which is relevant, or you can say the particular perspective in which the law should have been discussed. That has not been done, which actually has turned the table around. Had it been discussed, it would have been a different result altogether. In those cases, the plea of sub silentio is taken, and then the judgment so rendered if subsequent bench finds that yes, this particular point of law has not been discussed in a perspective, then that judgment can be kept aside and cannot be applied for the purpose of precedent or binding authority. So this is primarily per incuriam and sub silentio, whereby a binding precedent can still be taken exception to that they are not applicable. Apart from that, there are other ways of actually saying that a precedent is not applicable, but mostly these are the two tools which are used for the purpose of either distinguishing an earlier judgment or saying that they are not applicable at all. They do not have the precedential value. Now, just 1 second, I think. What binds and what doesn't bind, we have said that all residual binding. Now, thereafter, unfortunately, the page is not moving, but let me. Then the next point that we should be considering in the principle of precedent is that are high courts bound by the decision of other high courts? See, 141 says that a decision rendered by Supreme Court is binding on all courts and authorities in India. Similarly, the high court's decision are also binding on all the courts and authorities which are coming within the jurisdiction of that particular high court. The question arises that is a judgment rendered by one particular high court is applicable in other or is binding to the other high court also? Can a judgment of Delhi High Court bind a judgment a court of Rajasthan High Court or MP High Court or any other Bombay High Court? Now we know that every high court is the high court of that particular state and is the highest court of that place, and it's only under the Supreme Court as far as the binding value of the presidential or judgment comes into consideration by virtue of 141. So necessarily one high court is not bound as such by the decision of the other high court. Rather, it has a persuasive value. That means it would be guided by and would actually adopt the decision which the other high court has rendered, provided that particular high court on that particular point has not rendered any judgment or decision which is contrary to what the other high court is saying. So, and I'll give you an example of that. A very latest example is that under Commercial Courts Act 2015, there is a provision which is section 12 capital A, which says that whenever a commercial suit is filed, prior to filing of the suit, there is a mandatory provision of pre-institution mediation. That means you must go to the mediation cell before you go to the court. And by going to the mediation cell, you first try to mediate and settle the matter. If the mediation fails, only then you come to the court and file a suit. Now, as far as the nature of this provision is concerned, it is mandatory. It cannot be bypassed. The question on which various high courts have taken different view is that whether a suit is maintainable at all before exhausting first the recourse of section 12 capital A. Some of the high courts have said that it is not maintainable and it must be dismissed, while others have actually kept it pending on the file of the high court and have asked the parties to go and first avail the remedy of 12A mediation. Now, on that, there is clearly a contrary views taken by different high courts. Some says that no, it has to be dismissed, and they have dismissed it, saying first go, exhaust it, exhaust 12 capital A, then come. And some have not dismissed it, they have kept it pending on file. And during pendency, they have said, we are keeping it pending. You go in the meanwhile, because this is the mandatory requirement, exhaust it first. Now, based on different standing of the high courts, the matters at the moment is being considered by Supreme Court as to whether the suit should have been dismissed at all for the purpose of exhausting 12 capital A or not. And this is pending at the moment in Supreme Court. But my point is here that since different high courts have taken different view, assuming Delhi High Court says that it's not required to be dismissed, and I'll keep it pending and go, you exhaust mediation. Whereas Punjab Haryana says, no, it has to be dismissed, right? And it dismisses the suit saying it's not maintainable. How can you come straight away to civil court? First go and exhaust this remedy, I'm dismissing it. So suit dismissed. Now, if somebody in Punjab and Haryana High Court cites a case of Delhi High Court saying, no, it should not have been dismissed because Delhi High Court has taken this view, you keep it pending, then Punjab and Haryana High Court shall not be persuaded by that decision of Delhi Court. Why? Because the parent High Court has itself taken a contrary view that it has to be dismissed. Then it will be guided by its own decision. So that is the extent of binding and non-bindingness of a decision of one High Court on the other High Court, that it has a persuasive value till the time there is no contrary view taken by the parent High Court. Now, when we move further, then comes the question is that is Supreme Court bound by its own decision? Like we saw earlier, and we said yes, 141 binds not only the courts and authorities which are lower, it also binds, or we can say it's more of a judicial discipline which binds the Supreme Court from its own judgment. Now, what is binding is that any subsequent bench of the Supreme Court which is deciding a case in which the law is already settled by a previous bench, then it should be followed. There is no reason to take a contrary view just because the subsequent judges are not convinced of the law determined earlier. But then there are exceptions, and obviously based on the procedure which have been established, if the subsequent bench doesn't agree with the previous bench law laid down, then it refers the matter to the larger bench for settling of the question. And that is why we have seen right from beginning, ever since the Supreme Court has started functioning, a number of references have been made time and again. Some have been referred as many times as constitution of a 13-judge bench in the famous Kesavananda Bharati bench. There have been many matters which have been referred constituting 11 judges bench, which means that since there is a jump of 2 judges every time, which means that there are at least 7-8 times that the judges have on that particular point in law itself, subsequent bench has taken a contrary view. So from 5 judges, somebody did not agree. Subsequent 5 judges bench did not agree. It went to 7 judges. Then somebody did not agree with 7 judges. Subsequent 7-judge bench did not agree. It went to 9 judges. So on and so forth. Now, there is only one judgment which has been rendered by a 13-judge bench. There are many which have been rendered by 11 judge, and there are many more rendered by 9-judge bench. 7-judge is also many more, and 5 judges, umpteen. I mean, hundreds of decisions have been rendered by 5-judge bench, which is constitutional bench. So, the point is that Supreme Court is bound by its previous judgment. But we have seen that it's the doctrine of consistency which have been there. Law normally, law once settled, it's been always said that law once settled must be settled for a longer period, so that it doesn't create chaos and confusion amongst the lower courts and amongst the executives who have to execute and implement the law. Unless and until the question becomes so palpably and apparently conflicting that a reference is mandatorily required. But recently, we have seen a trend where the references have been happening on various occasions, in many cases. Now, before I take up this particular page, I would like to mention one particular judgment of Supreme Court, which is Pradeep Chand Parija. Now, Pradeep Chand Parija is a very important judgment which was rendered by the Constitution Bench, 5-judge bench in 2002. And this judgment is why it is important is that it was happening in the Supreme Court that a division bench, 2-judge bench, when hearing a particular matter, was not convinced or satisfied by the law settled by a 3-judge previous bench. And not being satisfied, it straight away said that no, there's something wrong with this law, so please refer it to the 5-judge bench. So the 2-judges bench, doubting a 3-judge bench decision, said refer it to the 5-judge bench. Obviously, because 3-judge bench decision is to be looked into by the 5-judge bench only, examined by the. This was happening on various occasions. 3-judge bench hearing a matter, not satisfied with the 5-judge bench decision, said no, refer it to the 7-judge bench. So the order is to say the question of law which has been settled by the previous decision of so and so, we for the reason cited above, we are not agreeable. We have our doubts, and we think this requires to be settled by a larger bench. Accordingly, this case is referred to the 7-judge bench. That order is to say. So there was no option but to constitute a 7-judge or 5-judge bench in order to consider. So what the anomaly which was happening then was, the anomaly which was happening at that point in time was that that a 3-judge bench decision, if not agreed upon by the 2-judges bench, straight away goes to 5-judge, which was a little awkward or to say improper. The Parija case in 2002, in the 5-judge bench, they came forward and settled the position. They settled many a law, but as far as the reference to the larger bench was concerned, they said that if a 2-judge bench is not convinced with the 3-judge bench decision, it will not refer it directly to the 5-judge bench. Rather, it will send the file to the Chief Justice and request constitution of a appropriate bench for reconsideration of this decision. And what will the Chief Justice do is that it will not straight away constitute a 5-judge bench. It will constitute a bench of coordinate strength. Assuming it's a 5-judge bench decision which has been doubted, then the Chief Justice will constitute a 5-judge bench. Assuming it's a 3-judge bench decision which has been doubted, then the Chief Justice will constitute a 3-judge bench. Why? It will constitute the coordinate bench for the purpose of looking into the question as to whether the doubt which the 2-judge bench has expressed is validly sustainable doubt, or a 3-judge bench, which is a coordinate bench, thinks otherwise. And if the 3-judge bench thinks otherwise, and it says that no, the doubt which has been expressed by the 2-judge bench is unfounded, and this judgment, previous judgment is very good, it's not required to be referred to the larger bench, then the reference will not be made to the larger bench. So it actually saved constitution of larger bench on numerous occasions. As we all know that we have limited number of judges in Supreme Court, and a constitution of 7-judge bench or 5-judge bench involves them for good number of days. A constitution bench matter is heard for months, many times 3-4 months. And an involvement of 5 to 7 judges in one particular court also affects the function and working of Supreme Court in the other courts because of the number of courts, less number of courts working at that point in time. That is the reason why Parija came into picture and tried and resolved it, and has resolved it, and which is being followed from thereafter. It's been followed many times, and many such references to the larger bench has actually resulted into no reference actually taking place. Why? Because the next bigger bench which was constituted, they found that there's no necessity of referring to the matter. And one recent example of that I'll give you, which is referred to here, is that if you recall, we'll take up. If you recall, this is a very important judgment that I'm going to talk about now. And this actually follows the procedure of Parija, and it's not only this judgment which follows Parija. There are many, but I've picked up this particular example because this is the latest one, and it pertains to very momentous and important decisions which have been passed by the Supreme Court. If you all remember Indira Sahni case of 1993, the Mandal Commission case, they were decided, and in that case, it was held that the reservation in promotion is not something which Article 16 provides for the SC/ST. Now, in 1997, probably, 1997 or 95, came a constitutional amendment which is, just give me 1 second. Let me refer to.
It was Article 16. It was Article 16(4).
No, I'm trying to recall that constitutional amendment, probably 77th or something, whereby, anyways, that was a constitutional amendment which came in 1997, whereby Article 16(4) capital A was inserted in the Constitution, which made it very clear that the reservation in promotion will be given to the person of the category belonging to SC/ST categories. So therefore, what Indira Sahni had earlier interpreted Article 16, saying it doesn't contemplate giving reservation in promotion to the SC/ST also. That was provided by the Parliament by virtue of amending the Constitution and inserting 14 capital A. Now, when 14 capital A came into picture, another judgment of Supreme Court came up and said, all right, 14A actually gives the promotion in reservation in promotion, but because of the speedy promotion which is happening of the reserved category, the consequential benefit will not come to them. Now, to tackle the consequential benefit question, came another amendment, probably 81st constitutional amendment, whereby 16(4)(b) was inserted. Now, and they said that consequential benefit shall be given to the reserved category candidates, SC and ST particularly. Now, constitutionality of both 16(4) capital A and 16(4) capital B was challenged in Nagaraj case, M. Nagaraj 5, and since the constitutional provision was challenged, all you people know that whenever the constitutional question of constitutional interpretation arises, Constitution requires forming of a 5-judge bench, which will be hearing the matter. So, since interpretation of constitutional provision was involved and constitutional provision was challenged, 5-judge bench in M. Nagaraj was constituted, which came out in 2006 with its decision and said that 16(4)(a), 16(4)(b) are constitutionally valid. Reservation which has been provided in promotion and the consequential benefit which has been provided is upheld. But it said that it cannot be applied simpliciter. It has to be applied only after determining after obtaining the quantifiable data. So the government shall, after a regular period, obtain data to see how much is the representation of this particular class in a particular cadre. So cadre-wise obtaining of data was said to be a quantifiable data for the purpose of determination of backwardness. No, for the purpose of finding adequate representation. Whether a data was required for the purpose of determination of backwardness, Nagaraj said no, it's not required. So it basically decided two questions. For the purpose of determination of backwardness, no data is required. ST and SC means they are backward for the kind of history they have, right? But for the purpose of getting promotion, reservation in promotion, there must be a data which must be obtained cadre-wise to show how much they are being represented. Is their representation enough there or not? If they are enough, if they are not enough, based on that, it will be provided. So in 2006, Nagaraj said that what happened in 97 by virtue of the constitutional amendment. That is valid, but it can be made applicable only after the quantifiable data is obtained by the government, right? So it made it subject to obtaining of quantifiable data. But what had happened in the meantime, the people had been given the benefit of 16.4a 4b, and they had been promoted, and they were enjoying it's like 10 years, and they had a settled position which was there, right? And it was not 1, 2, 3, or 5 persons. It was a whole number of people who had been getting the benefit of 16.4a and 16.4b. Subsequent to Nagaraja, in 2018, Jayanta Chakravarti was another 3-judge bench which doubted correctness of Nagaraja, saying that this judgment is not correctly decided. And on the question of backwardness and adequate representation, the matter must be reviewed by a larger bench. So it recommended the matter to be referred to the larger bench. Now, see, considering Parija, when Jayanto 3-judge bench said that 5-judge Nagaraja be referred to the larger bench, it didn't say refer it to 7-judge bench. It said larger bench be constituted. So Chief Justice constituted a bench of 5-judge bench in Jarnail Singh versus Lakshmi Narayan, which in 2018 itself looked into this reference by Jayanta, looked into Nagaraja, re-examined the issues, and said Nagaraja has been correctly decided in all manners. No reference is required. And therefore, what Jayanta said in 2018, Jarnail said there's no need. So actually, Parija punctured the involvement of 7 judges, which would have happened otherwise. That is why Parija is a very, very important judgment for the purpose of precedents and references and binding effect on Supreme Court decision. When we talk about procedurally, it's a very important tool when a matter is referred to the larger bench. So that was the idea of bringing this to the reference at this stage. Now, after this, just 1 second. I think it gets stuck for a while. 1 second. Yes. Now, having discussed this, we can now move to the next stage, which is power to overrule previous decisions and doctrine of prospective overruling. When we were discussing now this matter, previous matter of Nagaraja and references, we'll discuss another aspect which is pertaining to prospective overruling. I'll come to that, but before that, power to overrule previous decision is like well known. We all know, and we have seen, like I said right now, constitution of 13 judge, 7-judge bench, and 9-judge bench, and etc. etc. It only is an indicator that, of course, Supreme Court can overrule its previous decision where the law is found to be not suitably determined. We know that Sajjan Singh, Shankari, Shah, Golaknath, Keswananda, etc. went to 13 judges. This is a classic example of overruling the previous decision in a series of decisions, and which gave us all you people who have studied law, and all you people who have done the basic of constitution know there is something called basic structure, which was involved in Keswananda Bharti. The question was, though it's not relevant, but since it's so interesting that when it comes, a slight bit of touching is very, very much required. The question was whether Parliament can, while amending the constitution, whether Parliament can also amend the fundamental right. On that question, whether the law made by Parliament or amendment is a law within the Article 13 or not, different views were taken at different time, until Keswananda finally said that Constitution 368, Article 368 is a constituent power, which is not a law within the meaning of Article 13, and therefore there is no bar as far as Parliament is concerned in amending the fundamental right also. They can amend the fundamental right, but they cannot amend the basic structure. And then the ambit and structure of basic structure has been widened time and time again. And it's not only by virtue of a smart judgment in Keswananda, brilliant judgment Keswananda, what the Supreme Court did is that it limited the power of Parliament to amend not only the fundamental right basic structure, but also beyond fundamental right chapter 3 part, whichever things found the basic structure of the constitution, they said you can't amend. So that's how it happened. So yes, Supreme Court has power and to overrule previous decision, which is well known. There's no much discussion on this. One important aspect is doctrine of prospective overruling, and why it is important is that when we apply a judgment as a precedent, there are various judgments which have been given only the prospective effect for the reason, and which was done for the first time in IC Golaknath, for the reason that the law which was prevalent at that point in time had affected so many people, and so many people had followed that law and had attained a particular settled circumstance, which, if unsettled, would do great injustice. And so they said that, all right, we are determining the law which is against what has happened as of now, which is contrary to what has happened as of now. But since the benefit has been conferred of the law, earlier law, which is being overruled, and that benefit is settled for a long time, which affects so many people, we will not upturn the cart in as much as the people who have got the benefit of it will not be disturbed. So that is called the doctrine of prospective overruling, which is maximum done in tax matters, which Prakash you would know very much. Vodafone is one of the judgment in which it has been applied. In Jarnail Singh and Lakshmi Narayan 2000, the judgment that I'm talking about, which we discuss right now, in which Nagaraja case was referred to the larger bench, Jarnail Singh, that judgment itself, when the three-judge bench subsequently took up the matter, through L. Nageswara Rao judge, on 28th of January 2020, there they finally decided that for the purpose of application of reservation policy in promotion to SC/ST, quantifiable data is to be determined cadre-wise, and every other method was bad. When they finally decided that since till now either no quantifiable data or quantifiable data determined otherwise, not cadre-wise, but maybe group-wise or different unit-wise, they said, as of now, what has been done, there are many people who have got the benefit of it for over 25 years now. So they said that we are not going to unsettle it. Whoever have got the benefit of it, they will continue with the benefit. And they therefore applied Nagaraja judgment with a prospective effect, with effect from the date of the decision of this judgment. So on 2022, this Jarnail Singh versus Lakshmi Narayan, civil appeal number 629 of 2022, they held that we are applying this judgment Nagaraja prospectively, and therefore it becomes very important to see the relevant extract of this judgment, which makes a very interesting reading, which we can read on the next page. It says, this court in Golaknath and Ashok Kumar Gupta referred to above has laid down that Article 142 empowers this court to mold the relief to do complete justice. To conclude this point, the purpose of holding that M. Nagaraja would have prospective effect is only to avoid chaos and confusion that would ensue from its retrospective operation, and it would have a debilitating effect on a very large number of employees who may have availed of reservation in promotion without there being strict compliance with the conditions prescribed in M. Nagaraj. Most of them would have already retired from service on attaining the age of superannuation. The judgment of M. Nagaraja was delivered in 2006, interpreting Article 16(4)(a) of the Constitution, which came into force in 1995, as making the principle laid down in M. Nagaraja effective from the year 1995 would be detrimental to the interest of a number of civil servants and would have an effect of unsettling the seniority of individuals over a long period of time. It is necessary that the judgment of M. Nagaraja should be declared to have prospective effect. So basically, doctrine of prospective overruling is a very important tool for the purpose of molding relief, which Supreme Court has, and the effect on a precedential value of a judgment can be curtailed only for a prospective time. This is another aspect of precedent or judgment which are relevant. Now, having discussed these scenario, Prakashji, if there are other elements you can add, but I would say that these are the areas of precedent or the binding judgments and the manner in which they have to be followed and manner in which they have to be referred to the larger bench are broadly to be dealt with or to understood by every person who goes to the court or to the judicial authority for the purpose of arguing a case and relying upon a judgment. Now, thereafter, there are three instances that I had said in the beginning that I would bring up to show that how recently some of the judgments have been followed or not followed, or some confusion has been created for not following it, or following it but not referring it to the larger bench and taking a contrary view, etc., etc., by the coordinate bench. The three instances of first is the Commissioner of Custom versus Dilip Kumar and Company, which is the Constitution Bench decision on how an exemption notification should be construed in a tax matter, strictly or liberally. And then subsequent decision of Government of Kerala versus Mother Superior Convent, which has taken a view which has said that the Constitution Bench is not applicable, and despite being a two-judge bench, when it was considering the same question as to whether exemption notification has to be given a restricted meaning or a liberal meaning, it said it has to be given a liberal meaning. Now, why it said it has to be given a liberal meaning is very interesting to be seen. So that makes interesting reading of this judgment. Second is Pradeep Vinod Construction versus Union of India and Manraj Enterprises. This is a decision in which involves Arbitration Conciliation Act matter, where section 31 subsection 7 is a provision which says that if the parties by way of an agreement bar grant of interest, then arbitrator doesn't have power to grant interest as far as pendentility, pre-reference and pendentility interest is concerned. Future interest, he can, arbitrator can, there is no bar. Parties cannot agree to bar future interest, but pendentility and pre-reference interest, parties can agree to bar it. So how Pradeep Vinod has constructed has constructed a particular clause of barring provision, and how Manraj has taken a contrary view on that is again a very interesting reading that makes. And thereafter, State of Punjab, Baljinder Singh and S.K. Raju is again a very interesting judgment. Both are rendered by three-judge bench, in which Baljinder Singh has overruled a judgment which has been approved by S.K. Raju, three-judge bench. Overruled judgment is a two-judge bench, which is relied upon and approved by three-judge bench in S.K. Raju. But subsequently, Baljinder Singh overrules that two-judge bench decision without S.K. Raju being brought to its notice. So it becomes a per incuriam judgment. And today, the coordinate strength of three judges bench stand on two different footing. One says yes, other says no. And the subsequent decision which says no doesn't take into account the previous decision of coordinate bench which says yes. So these judgments will give a very good perspective on how the law of precedent has been used or distinguished or has been read by the different benches. Now, first we see Dilip Singh and Mother Superior Convent. Dilip Singh 5-judge bench was constituted as a 3-judge bench decision in Sun Export Corporation was doubted. Another 3-judge bench doubted it, which was presided over by Justice Gogoi at that point in time. They doubted the question which was decided in Sun Export, saying that ambiguity in tax exemption provision must be interpreted in favor of the SSC, and the benefit should go to the SSC in case of such ambiguity. When this question was referred to the larger bench, 5-judge bench in Dilip Singh held the contrary. It said that the exemption notification should be interpreted strictly. The burden of proving applicability would be on the SSC to show that his case comes within the parameters of the exemption clause or exemption notification. And it also said that wherever there is an ambiguity in reading the exemption notification, the benefits must go to the revenue and not to the SSC. So, and it overruled Sun Export. So, law was turned upside down in Dilip Singh. Exemption notification in a tax matter, which earlier came to the benefit of SSC and which was being given a liberal construction, now was being given a strict construction, and the ambiguity was going to the benefit of the revenue. Now,
Ajay,
Hanji.
In the same case, in the Dilip Singh case here, whether the issue of the Parija was discussed or not discussed?
No, Parija may not have been relevant.
Because in the case of Parija, it was decided by the court here, 5-judge bench here, saying that in the case when there was a doubt of the 3-judge bench here, then the matter should be two judge matter. There is a doubt of the order of the three judge bench. Then the issue should be referred to the another three judge bench here.
There are two aspects. I'm glad you raised this question. There are two aspects. Here, what is happening is the three judge bench is doubting a previous decision, which is of three judge bench. Correct. So when a three judge bench, coordinate bench doubts a decision of three judge bench, the only recourse is that the constitution of a five judge bench would be the next course, even as per Parija. Had it been a three judge bench doubting five judge bench, then the Chief Justice would not have constituted straight away a seven judge bench. Rather, it would have constituted a five judge bench to test the doubt of three judge bench. If the five judge bench also concluded that yes, it seems that the matter requires hearing by a larger bench, then, but this is not a case where three judge bench is already hearing a matter of earlier previous three judge coordinate bench decision and it's doubting it. So the next possible course would be that a larger bench will be hearing the matter. There is no other bench strength which would say that the subsequent doubt expressed by three judge bench is a good doubt or a bad doubt. There can't be any such bench. It has to be five judge bench which will look into the matter. That's why the matter was referred to the five judge bench. Assume, let's see this. Assume that a two judge bench is doubting a three judge bench decision, right? And it's recommending reference of the matter to the larger bench. In that case, Chief Justice would first constitute a three judge bench. A bench of coordinate strength, like it did in case of Lakshmi Narayan, when Nagaraja was doubted by a three judge bench decision, it's constituted a bench of five judge bench in Lakshmi Narayan, as per Parija, because that's the only next immediate larger bench which could look into it. But if three is doubting three, then the next course is five, which is why Dilip happened, constitutional bench. All right. So then under these circumstances, the law was completely upturned, upside down, and it happened in 2018. If I am correct, because 18 or 19, probably this judgment came. Dilip Singh.
This is the year 18.
18. Okay. Now, what was happening at that point in time is very interesting to note. Across the country, when Sun. This is Sun?
Yeah, Sun Exports.
Sun Exports. When Sun Exports was ruling the field and exemption notifications were said to be construed liberally, the entire country was working like that because there was a consistency and then people were following that law until Justice Gogoi doubted it. So across the country, laws were being followed and exemption notifications were being construed liberally, which happened at that point in time. And prior to that, in Kerala, there was a particular issue which was being debated and discussed, and that was the issue pertaining to property tax. And the question was that in the Kerala Act, Property Tax Act, property tax was being imposed on the buildings and residential buildings, etc., etc. And then there was an exemption clause which said that the buildings for the purpose of religious, charitable, etc. purposes, they will be exempted. The question which came up for consideration was that the building for religious purpose would mean the very building in which the religious activities are being performed, aartis are happening, or prayers are happening. But the buildings which are, or such buildings which are connected to that, but the buildings which are separately built by that particular organization for the purpose of housing those people who are performing the charitable function or religious function, that building, strictly speaking, is outside the exemption clause, and therefore, in the assessment orders passed by the authorities, tax was imposed. Matter raised to the High Court. Contention raised was that this has to be strictly construed, and this is I'm talking about pre Dilip Kumar case. It was happening in 2010, 2005, 2006, etc., etc. The number of cases came in Kerala High Court. So much so that one matter Kerala High Court constituted a full bench, three-judge bench, and 2010 it was decided by the full bench that these provisions have to be given a liberal construction because they are for the beneficial purpose, and the purpose is different. So state lost. State came in appeal. Appeal was filed and leave was granted in 2012, and matter was pending. In the meanwhile, Dilip Kumar happened, and the state had a very good case to argue when the matter came up for argument before Justice Nariman in 2019 or 20 in Mother Superior. Then they simply argued that, see, there is nothing to be argued now in this matter. It is already covered by Dilip. It clearly says that the exemption notification have to be given a restricted construction, and therefore the liberal construction which has been given by the High Court is clearly in the teeth of Dilip, and it must go. Very interesting aspect is that when this provision was analyzed by the bench, the provision was found to be a provision for the purpose of beneficial region, right? It's a religious, hospital, schools, etc., etc. And then Supreme Court chalked out a particular line of judgments, 6 or 7 judgments, in which Supreme Court had held that in contradistinction of the normal exemption notification, where the exemption is applied in case of a beneficial purpose, there the notification has to be given a liberal construction, keeping into consideration the object and purpose why the exemption is being given to the beneficial provisions. So this was a distinction drawn by Mother Superior Convent, that exemption in general is one thing, exemption for the purpose of beneficial provision is another thing. Beneficial provision exemption are the exemptions which have to be construed liberally. So, and second important point which Mother Superior Convent pointed out is that this particular line of decisions of Supreme Court, which have already held that beneficial purpose exemption notification have to be given liberal construction, they have not been discussed in Dilip. So in Dilip, this is kind of a sub silentio, you can say, or you can say that this question was not specifically decided by Dilip as to how exemption with regard to beneficial provision is to be dealt with. They were simply dealing with a situation of exemption notification in general. So a niche was carved out in this matter. A different set of fact was brought out, and that since the law is settled by Supreme Court by a line of judgment, there are 5, 6, 7 judgments which have been quoted there, in which they said that when it applies to the beneficial provision, it has to be construed liberally. And since those line of judgments have not been considered by Dilip, Dilip was held to be non-applicable. And the court very clearly said in Superior Convent that Dilip can be read only for the law that it has decided and not for the law that logically follows from it. So that concept of a precedent has to be the law for which is decided and not the law that logically follows from it, has been applied in Mother Superior Convent.
Jaji, if you allow me, I will read the relevant para of the Mother Superior Convent.
Please.
The relevant para is the para number 22, where they are making the distinguishing the Dilip Kumar case.
You're right. From 15 to 21, they have cited those decisions which and have 20, in which yes, and then 22 they conclude. He concludes.
Yes, from the 22.
He clearly says in contradistinction with.
Yes, I'm just reading because 22, 23, 24, and particularly last para 25 is most important para, where the Dilip Kumar has been said that it was sub silentio here. Okay, I'm just reading this one. A recent 5-judge bench judgment was cited by Sri Gupta in the Commissioner of Customs versus Dilip Kumar and Company, 9 SSC 1 2018, 9 SSC 1. The 5-judge bench was set up as a 3-judge bench in the Sun Exports Corporation, and Collector of Customs was doubted as a said judgment ruled that an ambiguity in a tax exemption provision must be interpreted as to the favor of the SSC claiming the benefit of such exemption. This court, after dealing with the number of judgments relating to the exemption provision in the tax statute, ultimately concluded as follows. So the judgment of the Dilip was as under, To sum up, the answer of the reference holding as exemption notifications should be interpreted strictly. The burden of providing applicability would be on the SSC to show that each case comes within the parameter of the exemptions clause or the exemption notifications. When there is an ambiguity in the exemption notifications, which is the subject of strict interpretations, the benefit of such ambiguity cannot be claimed by the subject SSC and it must be interpreted in favor of the revenue. The ratio of sun export is not a correct, and all the decision which took similar view in the sun export case stand overruled. So this was the Dilip judgment here. Okay. And in the para number 23, it may be noticed that 5-judge bench in judgment did not refer to the line of authority which made a distinction between the exemption provision generally and the exemption provision which have a beneficial purpose.
Absolutely.
We cannot agree with Sri Gupta contention that sub silentio, the line of judgment qua the beneficial exemption, has been done away with this 5-judge bench. It was settled that the decision is only authority for which it decide and not what logically follows from it.
Correct.
They have cited the Queens versus Latham and the state of Odisha versus Sudhanshu Sekhar Misra.
Yes.
And para number 24 is further important. This being the case, it is obvious that the beneficial purpose of the exemption contained in 3.1b must be given a full effect to, and the line of authority being applicable to the fact of these cases being in the line of authority which deals with the beneficial exemption as opposed to the exemption generally in tax matters, in tax statute. This being the case of the literal formalistic interpretation of the statute at hand is to be skewed. We must first ask ourselves what is the object sought to be achieved by the provision and construe the statute in accord with the such object, and on the assumption that any ambiguity arises in such constitution, since in such construction, such ambiguity must be in favor of which is exempted. Consequently, for the decision given by us, we agree with the conclusion reached by the impugned judgment in the division bench of the full bench here. So with this, they have said that Dilip Kumar judgment was not applicable, where the objective of the statute itself to give certain benefit to some property, and therefore in this case here, the Dilip Kumar judgment was said that it was, even though it cannot be said to be applicable, that part here. It rejected the contention of the applicant here that the Dilip Kumar covers this judgment here.
Right. So that is one very good instance of actually looking into the law of precedent and how a judgment is to be read, because as good as Dipankar Gupta, senior advocate, was completely satisfied that this is a matter in his favor. It's covered by the larger bench. So probably he was not prepared with many of the argument except this, that see, this is covered. And that second aspect completely missed the point. And very, but for the genius of Justice Nariman, this was a very fine distinction point which was brought up. And I have not seen that this has been argued by the other side. So it might be his mind. It might be just his mind. As a lawyer, he has done many things, so he must have caught it. And he said, let me apply this. All right. So that is one beautiful example of seeing the law of precedent and its application and how a judgment should be distinguished. Next topic that we pick up is the two decisions of Pradeep Vinod and Manraj Enterprises. Both decisions are rendered by 2 judges bench in 2017 and 2021. Like I said earlier, they are on the interpretation of a particular clause of arbitration agreement, whereby whether the interest is barred or not barred is the question. Now, in order to understand that provision properly, it is very important to see what section 31(7) of the Arbitration Conciliation Act says, which I have quoted here on this page. If that is visible, it can be seen. It says, unless otherwise agreed by the parties, that is the provision of statute. Unless otherwise agreed by the parties, where and in so far as the arbitral proceedings is for the payment of money The arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the, now this is relevant. Interest, arbitrator can give an interest unless parties have otherwise agreed. For which period? For the whole or any part of the period between the date on which the cause of action accrues or arose and the date on which the award is met. So the period which is covered is the date on which the cause of action accrued, which is before the matter is referred to the arbitrator, which is called pre-reference period. And from reference till award is called pendentility period. So for pre-reference and pendentility period, whether arbitrator has power to award interest or not is something which is governed by the will of the party. If parties agree in the agreement, they will say that no interest is to be awarded, it will not be awarded. Now, on this, there is a next stage of argument, which is quite a huge argument, and that itself will take at least 1 hour of discussion as to whether this is a correct proposition or not. But we'll do that in some other day. For today's purpose, we'll confine it to the extent that for pre-reference and pendentility period, parties can, by an agreement, restrain the arbitrator from its power to award interest. And let's see B next. A sum directed to be paid by an arbitral award shall, unless the award otherwise directs, carry interest at the rate of 18% per annum. Now, this is from the date of award till the date of payment. So this is future interest. Now, we all can understand one thing. When we talk about award with arbitrator and interest, there are 3 periods which are normally covered: pre-reference, pendentility, and future. Now, for future interest, there is no such power given to the parties to restrain it, but a discretion is rested on the arbitrator. Arbitrator can, it says, unless the award otherwise directs. So direction of the award is something which is to be based on the discretion of arbitrator, which the arbitrator will exercise in the facts and circumstances of the case. But the parties do not have power to restrain the arbitrator from granting future interest, unlike in clause A, where they can. Now, in light of this, came the question of interpretation of clause 16.2 of railways agreement, which railways in all contract that it gives to the contractor has a specific template terms and condition of special condition of contract, in which clause 16 covers the topic of earnest money and security deposit. And it says that for any contract which is won, the contractor has to deposit on earnest money, and 10% of the contract value security deposit is to be given. Now that 10% is the coffer, which can either initially paid by the contractor at all completely, or where this percentage happens to be 5%, the rest of the 5% shall be deducted by the employer from the running bills and shall be deposited till the time 10% is completed, and that will be retained by the employer or the contractee or the person who is giving the railway as a security. 16.2 says that there would be on earnest money, security deposit, and other payment under the contract, or amount payable under the other payment under the contract, meant for the purpose of completing the coffer of 10% of security deposit. 16.2 says that no interest will be given on earnest money, security deposit, and the controversial term is and other payment made under the contract. Now, whether this other payment made under the contract should be given a restrictive meaning in view of the head note, which says security deposit and earnest money, whether it should be given a restrictive meaning and be confined to the 10% amount which is payable under the contract, or whether it should travel beyond the head note and cover any payment which is to be paid to the contractor under the contract. It's the main point of controversy which has been taking place time and again. When it came up for consideration in Pradeep Vinod in Supreme Court 2017, Chandrachud was sitting with Kehar, and Chandrachud had written this order. He gave this the interpretation of a limited applicability. It said that this is only applicable to earnest money and security deposit. It cannot go beyond it. And number two, it also said that since there is an inherent power of arbitrator to award interest, whenever such a clause of a contract comes for interpretation, that clause has to be given a restrictive meaning. It doesn't have to be given a wide meaning, and it has to be absolutely sure from the contract that there was no intention to grant interest at all. Now, it appears that 16.2, there is no such unambiguity. It is very clear that it is coming under the heading of earnest money and security deposit, and it doesn't say that any money payable under the contract whatsoever. It says the money payable under the contract, which can be meant, which can be construed that the money which is only applicable to the 10% of the coffer. So it says that 16.2 is a restrictive term. It doesn't debar arbitrator from awarding interest on other money. So that's what the construction given. That's a two-judge bench in 2017. Now, what happened subsequently, that same clause came for interpretation in 2021 by another two-judge bench presided over Justice Shah, M.R. Shah. And M.R. Shah considered the earlier judgments, various judgments, and said that what Pradeep Vinod has decided in 2017 is not a good law, and therefore it took a contra view, and he said that this covers the entire thing. Now, what is happening here, that when we look into the law of precedent, what is happening here is that there are two things. Both the judgments are given by the two division benches. Bench strength is same. It is not that having disagreed with the matter, he has referred it to the larger bench, but he has said that this is something which is a bad decision. Why? Because earlier decision of a larger benches are there, which are holding otherwise, and therefore, so there can be two interpretation of it. One is that since the two benches of equal strength have taken a contra view, therefore it is available, the liberty is available to the subsequent bench or the lower court to apply either of these two judgments, which according to them and according to the argument placed before that particular bench is found more close to the law. Either of them are available to be applied. That's one of the way of looking at it. Other way of looking at it is that Manraj Enterprises basically says that Pradeep Vinod, being a two-judge bench, has not taken into account the earlier three-judge bench decision, and therefore Pradeep Vinod has to be ignored. That may be the other way of looking at it. So either way, the two-judge benches decisions are there, which are standing head-on to each other, and as far as wherever we and you or anybody gets an opportunity to argue a matter covered by 16.2, we should be knowing that there is another decision of Supreme Court which says that where two benches have taken a contrary view, knowing the previous decision. If they are not knowing the previous decision and subsequent bench takes a contra view, then the subsequent decision has to be ignored. Previous will prevail. But if the subsequent bench knows the previous coordinate bench decision and takes a contra view, then both stand, and the liberty is left to the subsequent court or the lower court to apply either of them which they are convinced with. All right. Now, so this is what the Pradeep Vinod and Manraj anomaly is as far as the application of precedent is concerned, which takes us to yes.
In my view, both the Pradeep Vinod and the Manraj was coming from the Delhi High Court, okay. And in the case of the Manraj also, in the Delhi High Court has also said that the Pradeep Vinod does not apply. And
no, other way around. Delhi High Court has actually awarded it relying on Pradeep Vinod. Single bench is division bench. Both have dismissed the appeal of government railway. Section 30. Arbitrator awarded the interest. Section 34 objection was dismissed by single judge. Appeal filed under Section 37 was dismissed by division bench. So basically, single judge and division bench both held that 16.2 does not bar arbitrator from granting interest, that which came to the Supreme Court. So actually, the government has come to the Supreme Court, Union of India. It's not Manraj which is coming. The decision was in Manraj's favor.
Yes. The decision was in Manraj's favor here. Okay. And in this decision, they have discussed what is per incurium. And I'm just reading para number 40 of the para number 9, and we discussed the
They are saying Bright Power was a previous decision of three-judge bench, which has held
Yes.
otherwise, which is not followed by the subsequent decision of two-judge bench.
Yes.
But there is a point of argument. But then, yes, that is the view, and that's why they are saying since the previous larger bench view has not been followed by subsequent decision, and therefore the subsequent decision can be ignored.
Yes,
That's the
it
law.
was, yeah. And in this case, they have discussed the issue of the incurium here, and they have discussed that what is the incurium. And just allow me to read this few lines.
Yes.
Incuria literally means carelessness. In practice, per incurium appears to mean per ignoritium.
Ignorance. Yeah.
English court have developed the principle in relaxation of the rule of stereodesis. The quotable in law is avoided and ignored if it is rendered in ignoritium of the statute or other binding authority. Young versus Bristol. Same has been accepted, approved, and adopted by the court while interpreting the Article 148 of the Constitution, 141 of the Constitutions, which embodies the doctrine of precedent as a matter of law. In Jaisri Sahu versus Rajdiwan Dubey, this court, while pointing out the procedure to be followed when conflicting decisions are placed before the bench, instructed a passage from the Hillsbury law of England incorporating one of the exceptions when the decision of the appellate court is not binding. Does the principle extends and apply to the conclusion of the law, which was neither raised nor preceded by any consideration? In other words, can such conclusion be considered as declaration of the law? Here again, the English courts and jurists have carved out an exception to the rule of precedent. It has been explained as a rule of sub silentio. A decision passes sub silentio in the technical sense that has come to be attached to the phrase when the particular point of law involved in the decision is not perceived by the court or present it to the mind here.
I'll point out something. I'll go behind this judgment actually. Now that this is the finding coming from Justice Shah, I'll tell you something in this. See, the one remarkable difference between all other benches which are saying that the grant of interest is barred by 16(2) and Chandrachud saying it's a limited thing. There's a marked difference in approach, and the approach, according to me, which Chandrachud has taken, is correct. I'll tell you why. See, the law is absolutely clear on the point larger benches have said, which Chandrachud considers in Pradeep Vinod, is that power to oust jurisdiction of arbitrator to grant interest must be construed strictly. It should not be readily read into the into contract. Okay. So first is the question of approach. How should a contractual clause be read? Grant of interest power is given to the arbitrator by virtue of the Interest Act, right? By virtue of the plain law, and by virtue of 3 Constitution Bench decisions of 1980s of G.C. Roy and Dhenkalal, Odisha. So there are 3 decisions in which they said that arbitrator has inherent power to grant interest for all the 3 periods: pre-reference, pendentility, and future, right? Therefore, the power is as good a power as the power of the court, correct? There's no difference as such. Now, when you are curtailing such power by way of an agreement, that agreement should not be readily read for the purpose of ousting this jurisdiction of the arbitrator. It must be construed strictly, and it must be construed by reading the contract in entirety. Now, these are the guidelines. Okay, this is how you approach to this before you come to the conclusion. Before you come to your decision, you must have to have a proper approach. Otherwise, your decision will be erroneous. Now, all the previous decisions, there are 3, 4, 5 decisions, including Bright. If you read those judgments, you will see that the court probably has not kept in mind the approach which is being discussed by Chandrachud, and the approach which, according to me, is the correct approach. If you discuss that, you will see that the contract, when it brings it, there is no occasion for a contract to be drafted in a manner that in a topic which is covered under security interest, so earnest money and security. There, why would a contract say entire interest should be? It'll only bar the interest which is referable to these two heads. All right. Then there is another clause in the contract, in this very contract, which says that the other money referred to in 16.2 shall be the money which shall be deducted from the running bill of the contract. Now, that is again a payment, that is again a payment under the contract, which is being deducted by the employer from the running bill for the purpose of 10% security. So if you read the contract in entirety, which none of the previous decisions have done, which have been relied upon by Justice Shah in this Manraj. Okay, so to my understanding, the approach was correct taken in Pradeep Vinod, and the other judgments in which I think that approach has not been taken up, and yet the conclusion has been arrived at, contrary to what Pradeep Vinod has said. It needs to be settled. Actually, the question is open, and Manraj, according to me, is it's something which it requires to be looked into both sides. So in an appropriate case, the matter may be referred to the larger bench on this point. But anyways, we'll come to that when it happens. Let's see the next.
Yes.
The last case comparison is S.K. Raju and Baljinder Singh. Both are the 3-judge bench decision. Now, before I discuss this, let me give you a background of it. These are the cases pertaining to Narcotic Drugs and Psychotropic Substances Act, NDPS Act. There are two provisions. The NDPS Act, all attendee of people who are attending who have done law and read this NDPS Act, they must be aware of 2-3 things. One is that Act has a very stringent provision. Two is that onus is on the accused to prove that he's not guilty. Onus is shifted by statute. 3, that provision of grant of bail is governed by section 37, which is very, very rigorous. And in some of the circumstances, bail is almost denied for all time, unless and until prima facie case is made out or judges express their satisfaction in writing that the accused is not guilty. So these are very difficult statutes. Now, wherever such difficult statutes are there, there are certain safeguards which are provided to the accused for the purpose of ensuring that right to life Article 21 is not abused. Now, 2 safeguards are there in the NDPS Act also. One is section 42 and one is 50. Broadly speaking, 42 says that whenever police goes to search, siege and arrest a person, then there are certain formalities to be done which are mandatory. They cannot be done away with, and they have to be complied with. Otherwise, the conviction would be vitiated. Section 50 says that whenever a search, etc., is to be conducted under section 42, the accused is to be mandatorily given an option if he wants the search to be conducted in front of a gazetted officer or a magistrate. If that option is not given, again, the recovery becomes suspicious and the conviction will become vitiated. Now, these are very, very important safeguards. Now, what is important again is that when you read section 50, which I have not extracted here, but section 50 says that safeguard is when the person is searched, right? Now, so when accused is bodily searched, he is to be given this safeguard. But when a bag being held by accused or the vehicle of the accused or something else, premises that are searched, this safeguard, this option of magistrate and gazetted officer is not required to be given. That's how the Supreme Court has interpreted it in 2003, 2004. Came a judgment in 2007, 2-judge bench, in that, which is Dilip case, right? 2007, Dilip versus MP, Madhya Pradesh. In 2007, a 2-judge bench held that even though search conducted from person yields no recovery of contraband, but search from which conveyance does, non-compliance of section 50 while conducting body search would vitiate conviction of accused. Let me elaborate. Earlier Supreme Court judgment says that 50 safeguard is required to be complied only when the body search is done. When anything else is searched, 50 safeguard is not required. You are not given to be, you are not supposed to be given an option of magistrate, gazetted officer, present search. Dilip said, in Dilip case, body as well as vehicle was searched. From body, there was no recovery. From vehicle, there was recovery. Trial court and high court dismissed the objection and convicted the accused, saying that body search, section 50 safeguard is not required, law is settled. From body there is no recovery, and therefore 50 is not applicable. Supreme Court said, sorry, whenever body is searched, irrespective of the fact that there is a recovery from the body, rather it's recovered, and in the same breath something else, vehicle or bag, etc. is searched. And if before searching the body, 50 is not complied with, option is not given, then it will vitiate. I hope I'm making my point clear. Then it will vitiate.
So what was the reason to take a departure from the
I'll tell you.
Settled rule?
No, very interesting. Very interesting. The settled law was were those cases where body was not searched. The premises were searched directly, or the vehicle was searched. Physical search was not conducted. Correct. Here, physical search along with premises or conveyances were conducted. Now, the question was, the plea of the prosecution was that, all right, no option was given, that there is no recovery from the body. Okay. Court said nothing doing. The moment you search the body, 50 comes into picture, and non-compliance of it will vitiate the things. Now, this decision of Dilip Singh was subsequently in 2018 was approved in the case of
SK Raju.
Right. And they said that if the body is searched and the vehicle is searched or bag is searched, and irrespective of recovery from the body, 50 is to be complied with. If no option was given of presence, search being in presence of gazetted officer, etc., then it will vitiate. So 3-judge bench actually approved SK Raju, which happened in 2018. In 2019, SK Raju's 3-judge bench. 2019, Baljinder came and took a contra view and overruled Dilip. And in Baljinder, SK Raju is not referred to. So what is happening in Baljinder, that it is actually overruling a particular 2-judge bench decision which has been approved by a 3-judge bench decision without being aware of the fact that a 3-judge bench has already taken a view approving it. So it would have been a case of a reference to the larger bench, but since this judgment was not brought to the notice of Baljinder in a subsequent decision, this overruling makes it a judgment susceptible and to be looked with suspicion or to be ignored, because the coordinate bench earlier has approved it. Now, so these are the three instances which have happened recently, which while reading immediately struck to me. And I thought it makes a very good analytical thing for the people to understand that whenever we talk of precedent or whenever we talk of applying of a judgment, there are various elements that we have to look into. And like I said in the beginning of the discussion when we started, that 90% of the cases in courts are fought on the basis of decision, applicability of it, non-applicability of it, changed circumstances, prospective overruling, etc., etc. And therefore, it becomes singularly important that the law of precedent must be understood properly, must be read properly, and must be applied properly in order to make your point convincing to the court. I would then conclude myself. Thank you so much for hearing me.
Thank you, Ajay. If there are any question, we can discuss here. And can you, Ajay, just we can have some discussion on the issue of the whether 141 will apply to the Supreme Court itself. And it was the Bengal immunity case. First case was there that was discussed. Bengal immunity case. Can you highlight that case also, something?
Just 1 second. I think suddenly.
No issue.
No, 1 second. the power has gone. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. Now, to my understanding, there is no reason to exclude Supreme Court from all courts. And therefore, I would say, on first principle, that it should be applicable to the Supreme Court as well. And as far as the bench strength that we discussed, a smaller bench, a coordinate bench, must follow, not only because of the judicial discipline or judicial propriety, but also because 141 mandates so.
Sometimes it happens that because the term is very important, which is the law declared. When it says that it is the law has been declared, because in our practical cases, we find that sometimes in the Supreme Court, SLP is dismissed in limine.
SLP that's a different. Those would be different things. Law is only declared when the facts and law are discussed in extenso and applied in extenso. If it's in limine dismissal, then obviously it'll not become a ratio or a precedent to be cited.
But one thing is that in the case Supreme Court, many times I have seen the order heard, dismissed.
Which is limine dismissal, which will not apply, which cannot be cited as a precedent.
Yes. Can we say that when the matter was heard, everything was heard in proper manner, and after that it has been discussed?
It's very interesting. See, there is a different aspect in this. When what happens is, if you there was a judgment in 2001 which talked about merger of an order. Whenever, see, 136 is a jurisdiction of the Supreme Court, which is not an appellate jurisdiction, rather a special jurisdiction of exercise of discretion, right? So when a court hears and says dismissed, it only declines to exercise its discretion. It has not applied its mind on the matter, in the sense that the High Court order or judgment has not merged into the Supreme Court order. It remains a High Court order, correct? That's how Kunai Ahmed said this. So it's only a declining of the discretion of exercise of discretion by the Supreme Court to admit the matter. So a limine dismissal will not be taken as a precedent, according to me.
Okay, what happens when sometimes High Court passes the order and it says that heard and dismissed, and further we knowing that it is an appealable order? How to?
No, it has to be set aside. It will be set aside. It'll be non-speaking order. Justice Pasayat, in one of the cases, he used unscrutable face of a sphinx.
Yeah.
When this order goes to Supreme Court is not able to understand what happens. So what will decide? He'll immediately set aside and remand it.
Yes. Okay. So if the High Court passes this type of order, heard, dismissed, then we can expect that we can get the matter set aside by the High Court, and it will again come to the High Court.
Yes.
Then it will come again with the remand. It will come.
Yes. There is one more aspect of it. Many a times High Court says heard, dismissed, regional order to follow.
Yeah.
Correct. That also is a bad order. There's a case called Jagdev Singh Talwandi, in which they have taken up this matter and they said these kind of orders cannot be passed. Either you reserve the judgment and pass a complete order subsequently, or if you are giving the final order now, give the region also. Region must, if the conclusion is coming and region is not being preceded by region, the order itself is bad.
Ajay, I will like to read one of the judgment of which was there in the Punjab versus Vaxing case here. And here it has been discussed here, what we have just now discussed here. When a court passes this type, High Court passes this type of order, what the Supreme Court looks into this part here. That was the Punjab versus Vaxing order. It says that, I'm just reading that, when the court passes the order, it has just been dismissed. It says that even in respect of the administrative order, Lord Denning MR in the Brain versus Amalgamated Engineering case here observed that the giving of the region is one of the fundamental of the good administration. In Alexander Masonry, this one here, it was observed that failure to give region amounts to denial of justice. In many cases of the income tax matters, what we have heard that, what we have faced that, particularly in the case of the bogus or the, you can say that penny stock matters, the assessing officer comes with a predetermined mind here, that the assessee who has some long-term capital gain on account of sale of the equity shares, and this long-term capital gain may be the higher amount, they always come with a notion that this gain is a SAM transaction, this game is a fictitious game, and they will, whatever will be the evidence that will be submitted before the assessing officer, they will just follow the report from the investigation wing, and after this the conclusion will be that they will not touch upon the merit of the evidence which the SSC has submitted, and they will pass the order saying that the SSC has, the transaction of the SSC was a SAM transaction, and therefore they will tax it here. What I find that without giving the reason, without giving the, or without confronting the evidence which the SSC has submitted during the course of the assessment here, I am finding the strength from this type of judgment here. It says that even in the case of an administrative order, Lord Denning, this one here, in the case has observed that the giving of the region is one of the fundamental of the good administration. In Alexander Mystery versus the Crabtree, it was observed that failure to give region amounts to denial of justice. If the SSC is passing the order against you, and if they are not giving the region, then it is amounts to denial of justice. Regions are like links between the minds of the decision maker, decision taker, to the controversy in questions and the decision or conclusion arrived at. Region substitute subjectivity by objectivity. Very much important line which is trying to say. The region
Yes.
tries to subjectivity, replaces the subjectivity of objectivity. It emphasis on recording region is that if the decision reveals the insecutable face of the
Of Sphinx.
of Sphinx here.
Precisely the line that I quoted right now.
Yeah, it can be by the silence rendered it
Yeah,
virtually
Bhag
impossible.
Singh is by Justice Pasayat, is it?
Yes, Bhag Singh is the justice. No, I will tell
Pasayat.
you.
Pasayat.
Yes, Bhag Singh is the, no, is, yes, Arjit Pasayat.
Yes.
And it can be silence. The emphasis of the recording of these ones, or the region is to be indispensable part of the judicial system. Recording is sufficient. Another rationale is that can be affected party can know why the decision has gone against him. One of the salutary requirement of the natural justice is spelling out the reason for the order made. In other words, speaking out, the insecutable face of the springs is ordinarily incongruous with the judicial or quasi-judicial performance. Many times we have seen that in the case of the 147 assessment, the 148 notices, and when the reason to believe is issued to the SSC, we will find that there was no any detail which has been given by the assessing officer. Assessing officer simply quoted the report of the investigation wing, and based on the investigation wing, they have passed on the order, or they have started the reassessment of the SSC, saying that they have the reason to believe, without giving any satisfaction note. I find that this type of judgment, which says that the order should be, particularly in the quasi-judicial performance, where the assessing officer is performing the quasi-judicial performance, he must write a speaking order saying that what are the grounds on which the assessment has to be made, what are the ground why he understands that there is a income, there is an escapement of the income. And this is I feel that this is the case where we can discuss in detail to defend the 148 assessment here.
I agree. Correct.
I feel that it is already 7:57. We have already nicely spent 2 hours on the discussion. Many more things remains here. I can understand. I have culled out around 25 judgments here to discuss. And I am thankful that Ajay ji has covered everything here. Yes, now we can understand the Dilip Gupta cases here. It can also be argued saying that Dilip Gupta case cannot be applicable in the case where
absolutely.
And particularly one of the cases which I can understand, it was one of the Malawai cooperative society, which was from which was the Nariman judgment here. Although in this case the Dilip Kumar Gupta was not argued, but yes, I can find that if it would have been argued by the respondent, then it could have taken the same fate here. Ajay, I have few judgment also which is important for the purpose of discussing the issue. The one thing that can you just find out, just 2 line here, how to find a ratio decidendi in a judgment.
Ratio decidendi, yes.
Yes, how to find out.
Region of decision. It's the word. If we break the Latin into English, it becomes very simpler for us to understand. What is the region for the decision? So ratio is always to be found out by examining the facts. In the absence of facts, there can be a ratio. So I always say to all my junior colleagues that please do not read judgment randomly. Read first the facts. See, is it strikingly similar to the facts you're working on, or is there some difference? Only when you find the facts of that case similar to yours, go ahead and read the judgment if you want to apply that for your favor, in your favor. If the facts are different, then different facts may lead to different conclusion. That conclusion may not apply in your case, right?
Yes.
Therefore, a conclusion arrived by application of law on a given set of fact alone will amount to ratio of that judgment. Everything else is
arbiter.
Yes. Everything else is arbiter.
Okay.
If we run through a judgment, we always come across 1 or 2 point of determination. That 1 or 2 point of determination actually constitute the ratio of that decision, nothing else. If we know that question, if we have understood that question, which is to be decided in that matter, then we have understood the ratio of that matter case.
Okay. I can see one hand has been raised here.
Yes.
By Ashok Sharma sir. Ashok Sharma sir, can the Studycafe, can the admin can allow him to speak, because we are very less number of people, 11 people only. So if you can,
sure sir.
Can you ask her to, can you allow everyone to speak here, whoever want to speak here?
So Ashok sir, you can unmute yourself. I have allowed you to speak, so you can unmute yourself and then you can speak. Ashok sir, if you are there, and if anybody else also want to speak, they can raise hand and then I'll allow them to speak.
I feel that he has left the meeting.
No, he's there. He's still there, and I've allowed him. Ashok sir, are you there? Sir, yes. Ashok sir, yes.
Yeah, can you hear me?
Yes, sir, we can hear you.
Yeah, thank you. At the outset, I was too impressed to have such a lengthy discussion by Mr. Ajay ji.
Thank you, sir.
We chartered accountants have limited knowledge about the everything law, precedent, etc. I would like to correlate with all these income tax cases anyway. But then one thing I learned for today is that you ask any chartered accountant or any professional, he will say Dilip Kumar now have taken a view that it is to be interpreted very strictly. But they are not aware of this mother superior judgment.
All right.
So I really got a very good feedback today from this mother. Till now, I have heard that Dilip Kumar is not a good law. But then later there are judgments. But one Mr. Raghuraman from Bangalore has analyzed that in some of the seminars. But I could not listen to that. Today I was too impressed to have got this knowledge. Secondly, sir, now see, generally, suppose Supreme Court judgment is there, earlier Supreme Court judgment.
Yes, sir.
I'm just referring to the Dharmendra Textile on penalty matter.
Mhm.
There were so many judgments which have taken a particular view.
Mhm.
But later on in Dharmendra Textile, view was taken against. But those earlier judgments were not considered in in Dharmendra Textile case.
Mhm.
So, what is the legal position? Whether subsequent law is binding, or because they have not considered the earlier
I'll
judgment
tell
it
you,
is
sir.
per incurium.
I'll tell you, sir. Very relevant question you've asked.
Yes,
Relevant to the topic that we discussed today.
yes, sir.
Uh, First of all, thank you very much for being there in the discussion and listening to it. And I'm glad that you got an idea of Mother Superior, which is a view taken contrary to, or not
Yeah,
contrary, but a different view taken from Dilip and a way out for Dilip. Now,
yeah.
coming to your question, sir, Dharmendra has, like you said, on penalty has taken a view which is contrary to the earlier view taken by various benches. Now, the first scrutiny would be the bench strength of the previous judgment and subsequent judgment. If the bench strength is coordinate, then like we discussed right now in that arbitration matter, that coordinate bench strength, or in that NDPS matter, that coordinate bench strength, if they take a view, contrary view, without taking into account the earlier judgment, then they will be said to be per incuriam. Subsequent decision will be said to be per incuriam. If they discuss the previous judgment and take a contra view, for some reason, they should not. Coordinate bench should not. But if they take for some reason, citing citing one of the reason that the previous judgments have not taken into consideration even larger bench previous decision, then in that case they can take a different view, and both view will stand for the subsequent bench to be argued before. But in case of Dharmendra, assuming that the previous benches are larger bench decision, then Dharmendra is to be ignored. Like you said, Dharmendra has not considered the previous bench decision. Therefore, Dharmendra will not prevail. Previous benches will prevail because Dharmendra is per incuriam and a subsequent decision.
Right, sir.
Yes, sir.
Secondly, sir, this Dilip Kumar case is on exemption notification.
Right, sir.
What will be the position when we are interpreting the provisions of the Act? The same thing will apply. Suppose the provision is beneficial to the SSE.
Mhm.
I'm talking about, it is not exemption notification.
Mhm.
We are discussing, suppose we are interpreting a provision of the Act.
Mhm.
Then what will be the position? Same ratio will apply? You got me?
I got
Yes,
you, sir. I got your point, sir. Yes, Prakash.
Yes, sir. Yes.
yes, I'm look the same view, Ajay, which we were discussing
Dilip
in
has taken.
the Dilip has taken. Dilip was discussing a particularly exemption notifications here. Okay. The same was the issue how to interpret the beneficial provision of the statute. In the case of Malawai case here, Malawai Cooperative Society, it was Justice Nariman also. They have stated the same thing because it was a beneficial provision for the SSC. It has to be
Liberally
interpreted.
construed.
Yeah, it has to be beneficially construed, looking into the object and region of the provisions here.
The philosophy behind the interpretation is same. What is the object?
Yeah, object and region for this. And you will find that the same thing which has been taken in the case of the Kerala High Court, Kerala matters also in the case of the this judgment here, which is
Mother Superior.
Mother Superior. They are reading Mother Superior Convent. They are saying that because of the object was to give the beneficial provision to the SSC, so therefore it cannot be said that it has to be strictly construed here. Look, what we are reading, like in the case of the tax law, it is the purpose of the tax law is to collect the revenue.
Correct.
The moment we try to save the revenue, like by way of certain exemption, by way of certain notification, or by way of certain provision, the onus will shift to the SSC that yes, I am squarely covered
under that exemption clause.
Yes, covered into that exemption clause.
Yes.
And that only that Dilip Kumar says here. Like suppose that in the case of the income tax, the government has to collect the revenue from the SSC. SSC wants to say that no, I will save that tax by depositing some amount to the LIC. So LIC is covered under ATC. You can pay up to certain amount and you can get the deduction of that amount. So therefore, this onus is on the SSE to satisfy to the AO that he has actually complied the condition of the ATC in
Correct.
order to get out from the tax net.
Correct.
The object, like if you go, so if you say the Consumer Protection Act, it is a pro-consumer. It is a consumer protection. It is a pro-consumer here. If like any other age, like if you say the RERA is a pro-home buyer.
Home buyer.
Yes, they are the other, because they are the beneficial provisions here. Like if you say that, like some other provision like POSCO will be always a beneficial to the accused here or the victim here who was the below the age of the 18 years, because something is there. Yes, we can say that. Similarly, in the case of the income tax here, whenever we are getting the exemption, when we are claiming the tax benefit, we must satisfy the issue here. And I feel this is the same way that Dilip Kumar says here.
Yeah, one more thing, sir. Hello.
Yes, sir.
Yes, sir.
Yeah. See, generally, what even if it is a jurisdictional high court judgment, assessing officers' point of view is, because we want to keep this matter alive, I will not follow this judgment because we may win in the Supreme Court. In Supreme Court, it may be in favor of department. How to meet such type of things, sir?
So this, if I understood your question correctly, sir, probably the High Court is not disposing of the matter in light of the fact that the similar question is pending before the Supreme Court. And
no, I am saying, sir, as now the jurisdictional High Court judgment is there.
Yes, which is in favor of SSE.
Even in favor of SSE, but the assessing officer does not accept on the ground that maybe tomorrow in Supreme Court it may be in our favor, and because we want to keep the matter alive.
There is no justification for assessing officer not to accede to that. I'll tell you the position in law. What an individual does is a different thing. Position in law is that as long as the High Court order is in your favor, which is in challenge before the Supreme Court, and if there is no stay operating, then that judgment is governing the field till the time it's upset, right? As if there is a stay, then the government then that judgment is not governing the field, right? There is a cloud in the judgment. Though the judgment is in your favor, there's a cloud. But just because there is an appeal pending and no stay is operating, the judgment of High Court is still governing the field, and there is no reason for the assessing officer not to decide the matter in light of the prevailing law. If the AO doesn't do that, it doesn't do that. That's a subjective thing. That's not what the law says.
It may amount to contempt also.
No, I don't know. You can try for a contempt. Yeah, you can see. This is one of the remedy. You can try for a contempt, saying it's not being decided, but the assessing officer can give some administrative reason for not deciding it. But then the moment you move for a contempt and notice goes of a contempt, it'll be immediately disposed of.
Right. Thank you so much, sir. There are others would like to. Otherwise, dil mange more. Kitna hi discuss karo. For us, it is very useful. Yeah.
Thank you, Ashokji, for your questions and participation. Thank you so much.
Ajayji, for this matter, there is an amendment in the Income Tax Act from this budget. Section 158BA has brought into the act here, which says that if any matter which has been decided in favor of the SSE and the department and in favor of the SSE and the department is an appeal or department wants to appeal and the matter is something before the High Court or Supreme Court here, then the High Court or the department may not file any appeal further subsequently till the disposal of the order by the High Court or Supreme Court. So there is a one collegium system has been come into the income tax provision also. Income tax also 158BA, which is there, which is a collegium of the commissioner, which will take a call.
So statute said it's not necessary for him to file an appeal because the similar question is being considered by the High Court.
Yes.
And therefore, if he's not filing the appeal, the execution of that order is not required to be done, in the sense that the order which is in favor of SSE is not required to be executed or given effect to.
They are saying that they will not file the appeal. They will not execute it. They will not execute this order also because the similar matter is pending at the higher forum, and they will wait for the disposal of with the higher forum. But
There-
for this,
there is so if we look into the object of bringing this statute in the book, one of the object would be that don't multiply the appeals, right?
yes,
Correct.
don't,
Right.
yes,
Now that is a good object, but does the statute also provide for the consequences that since you are not filing not to multiply the appeal, by virtue of the fact that the appeals are pending, this the order which has been in favor of assessee should not be given effect to.
yes,
Does the
yes.
statute also say so? Does the statute also say so, or it
I have
leaves
to-
it open?
Yeah, it leaves it open.
So now if it leaves it open, then it's for the assessee to actually push the order for the execution. If it's in order, suppose there's a refund in favor of assessee, then the assessee can push for execution of it so that the refund comes to it.
Yes,
And
we have to see that aspect
yes.
here.
Yes,
We have to see this aspect here.
correct. So since the statute has brought this up point, so it must have taken care of completely of this situation. I assume there might be some provision which might be taking care of this aspect also. But if
Yes.
not, then like Sharmaji said that yes, it's open to assessee to actually press the cause and seek execution of the order in its favor.
Yes. Thank you, Madam.
Thank you, Ajay ji, and thank you, Prakash ji, for involving us in this good studies.
Thank you, sir.
Yeah.
Thank you,
It was a
thank you,
pleasure.
sir. I am the student of Sarma sir. Sarma sir is the
No, not
Sarma
at all.
sir. Sarma sir is our mentor. We have
Yeah.
learned. From his age we are learning. So we should get the inspiration from him.
I
Thank you.
completely agree, sir. Thank you so much.
Thank you, Studycafe, madam. Thank you, Studycafe, and thank you for all those participants here. I know there are less number of participants due to Saturday, but I will like to announce that we are all Saturday. We are just discussing the Supreme Court judgment. If you are interested on the Supreme Court judgment, please be with us. We discuss the various issue that is coming from the Supreme Court judgment. Yes, on this Saturday, we don't discuss the income tax cases particularly because as a chartered accountant are known for discussing the tax matters. But on Saturday, we don't discuss this heavy matter of the income tax. Yes, we discuss the other important matter in the presence of Ajay Kumar ji, other advocates in our group here. Thank you. Thank you, ma'am. Thank you for giving the opportunity.
Thank you, sir. And the session was really good. And friends, all the recording is available on YouTube. So in case you have missed something, you can watch it on YouTube anytime. So all the participants who are present on Zoom and the participants who are there on YouTube as well. So, many people are asking me about the PPT. So after the webinar, I'll connect to Prakash sir and Ajay sir, and I'll ask for the PPT, and I'll share the PPT in the Studycafe groups. I'll share it on WhatsApp also, and I'll share it on Telegram group also. And what I'll do, I'll create one link on the YouTube as well. So whenever you want to see, you can download the PPT and you can have a look on the judgments. And indeed it was a very excellent judgment discussion. और बहुत सारी ऐसी बातें बताई हैं अजय सर ने और प्रकाश सर ने जो बहुत ही कम प्लेटफॉर्म्स है जहाँ पे आपको ये सारी डिस्कशंस देखने को मिलेंगी. थैंक यू आयुष जी. ओके, यस यू विल ज्वाइन. सो इन केस आप लोग किसी को नेटवर्क प्रॉब्लम भी आई है एक दो लोगों को, तो ये वेबिनार यूट्यूब पे अवेलेबल है. आप यूट्यूब पे जब चाहें आप देख सकते हैं. थैंक यू अशोक सर. And again, it was a very amazing presentation. Sir, with your due permission, should I end the session now?
Yes, ma'am. Thank you, ma'am.
Okay.
Thank you.
Thank you
so
so
much, ma'am.
much, sir.
Thank you.
Thank